Hi, I'm Kayla, and I'm here with Sophie, and we're from the Global Human Rights Clinic at the University of Chicago Law School. Today, we're going to be discussing the right to education, which is the right to receive instructional services at public expense. First, we'll be discussing the international human rights system and what various instruments have to say about the right to education. The foundational international human rights instrument is the UN Declaration of Human Rights. Article 26 specifies that everyone has the right to an education. At the elementary level, education is free and compulsory. Higher education is designed to be equally accessible on the basis of merit, and university level education should be made generally available. Education is designed to enable people to achieve the full development of their human personality. And this means that education should strengthen people's respects for rights and freedoms and promote international community building. In addition to individual rights to education, parents have the right to choose the kind of education that should be given to their children. The International Covenant of Civil and Political Rights in Article 18, Section 4, says that states undertake to respect the liberty of parents and legal guardians to ensure the religious and moral education of their children in conformity with their own convictions. The International Covenant on Economic and Social Rights imposes certain obligations on states. States are supposed to enable their people to fully realize their right to education. Article 14 also establishes that there's a time frame for states to achieve a detailed action plan for the progressive realization of the right to education, and that's within 2 years of becoming a party to the convention. The three international human rights instruments that I've discussed, UNHR, ICESCR, and the ICCPR, are sometimes referred to as the International Bill of Rights, but these are not the only instruments that discuss the right to education. The Convention on the Rights of the Child, somewhat intuitively, discusses the right to education. It specifically discusses that education should enable children to explore their own cultural identities. Education should also enable children to develop respect for their natural environment. The Convention on the Elimination of All Discrimination Against Women, in Article 10, discusses specific concerns that women may have as they're going through their educational experiences. It requires states eliminate any stereotyped concepts of the roles of men and women at all levels and in all forms of education, and it requires that states provide equal opportunities for men and women in areas such as scholarship funding or access to sports and physical education. A number of regional instruments also specifically include the right to education as an affirmative right, the African Charter, the American Declaration, the Protocol of San Salvador, and the European Convention on Human Rights. We're going to be discussing the European Convention later. A number of states also include the positive right to education in their constitutions. So what does the right to education mean in the international system? The Committee on Economic, Social, and Cultural Rights provides some guidance. The committee is a body of 18 independent experts that monitors the implementation of the International Covenant on Economic, Social, and Cultural Rights. The committee, in a general comment, specifies that education must be characterized by 4 general qualities. First, availability. Second, accessibility. And this accessibility refers not only to economic accessibility, but physical accessibility of educational facilities, as well as the ability of all to access education without any discriminatory bars. Third, acceptability. Education must generally be of a certain quality, and the material must have relevance and be culturally appropriate. And fourth, adaptability. The committee also concluded that the right to education must be accompanied by academic freedom, and that institutions of higher education are required to have a degree of self-governance. Now we're going to move on to discussing the right to education in the US. The right to education is not an enumerated right in the Constitution. Education has been viewed primarily as a state responsibility, not a federal responsibility. Today, all states protect the right to education in their state constitutions, with the possible exception of Mississippi. Mississippi, however, does its educational protection through statute. San Antonio Independent School District v. Rodriguez was an important federal case on the right to education. The case followed Griffin v. Illinois from 1956. This case established that the distribution of important government services unequally on the basis of wealth was a violation of the Equal Protection Clause. The case also followed Brown v. Board from 1953, which established that education is perhaps the most important function of state and local governments. It is required in the performance of our most basic public responsibilities. It is the very foundation of citizenship. It is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education, and such an opportunity, where the state has undertaken to provide it, is a right which must be made available on equal terms. The plaintiffs in this case were school children who were residing in property-poor school districts in Texas. Texas, at the time, relied on local property taxes to finance public education, and the quality of education varied widely with the wealth of the district. The plaintiffs brought a claim under the Equal Protection Clause, alleging that this system was discriminatory. The Supreme Court denied the claim, applying rational basis scrutiny instead of strict scrutiny because it held that education was not a fundamental right. Because education wasn't explicitly or implicitly guaranteed by the Constitution, it could not be considered fundamental. The plaintiffs pushed back and argued that education was implicitly guaranteed by the Constitution. Education bears a close relationship with other liberties accorded protection under the Constitution. The First Amendment, for example. The right to speak is meaningless unless the speaker can articulate his or her thoughts intelligently and persuasively. The right to vote. One cannot intelligently cast ballots unless they can read, and literacy is acquired through schooling, and one cannot meaningfully cast ballot if their thought processes haven't been adequately developed. Critical thinking skills are also gained through education. The court was not persuaded. While the court acknowledged that education could have bearing on other rights that were constitutionally guaranteed, the court also held that people weren't guaranteed the most effective speech or the most informed electoral choice under the Constitution. Even if there was some constitutionally protected level of education, the court held there was insufficient evidence to suggest that Texas's educational quality was constitutionally deficient. In Pyler v. Dove, decided about a decade after, the court said that public education is not a right granted to individuals by the Constitution, but it's not just some government benefit that's indistinguishable from other forms of social welfare legislation. The court was deciding on whether a Texas statute denying undocumented children access to free public education was unconstitutional. The court held that it was unconstitutional because it explicitly went against one of the Equal Protection Clause's aims, the abolition of governmental barriers presenting unreasonable obstacles to advancement on the basis of individual merit. The court upheld this reasoning in Grutter v. Bollinger in 2003, where it found that University of Michigan Law School's affirmative action policy was not a violation of the Equal Protection Clause. Diversity in education serves a compelling government interest in sustaining America's political and cultural heritage. So, as a result, Texas was required not to exclude undocumented children from access to free public education. This idea was confirmed on the international level by the Committee on Economic, Social, and Cultural Rights in a general comment. The committee held that non-discrimination extends to all persons of a school age residing in a state's territory, including non-nationals, irrespective of their social status. The Supreme Court hasn't been totally clear in how they've been deciding education cases. Sometimes they've extended the right to education, and other times they've restricted it. Because of this, the state level has been more of a focus of reform than the federal level. So we're going to turn now to the right to education in American states. Litigators have taken a couple of approaches in challenging the educational services afforded by states. One of these approaches has been reliant on the equal protection argument. This is the approach that was taken in Vermont in Brigham v. the State. This case concerned the funding of public education in Vermont. Education is the only governmental service enumerated in Vermont's constitution. Vermont also has a common benefits clause, which requires that the government provide services for the common benefit of all in Vermont. In effect, government services must be provided on an equal basis. If it isn't provided on an equal basis, then there needs to be some legitimate governmental purpose. However, there wasn't one here. The state didn't explain why the funding system necessarily required local control. A second approach has been to challenge the legal adequacy of education. Generally, this approach has been more successful at the state level because there's no alternative education system that necessarily has to be deciphered. The North Carolina Supreme Court defines sound education as requiring four things. First, it required that schools provide basic literacy skills and math and physical science skills to students. Second, it required that schools provide basic social studies education to enable students to make informed choices with regard to issues that affect the student personally or that affect the student's community. Third, the court required that schools provide academic and vocational training to enable students to successfully engage in post-secondary education or further vocational training. And fourth, that schools provide the necessary skills to enable students to compete on an equal basis with others in further formal education or gainful employment in society. School finance litigation under state constitutions has been brought in 45 states, and in 26 of those states, the litigation was successful. But the beneficial effects of this litigation is unclear. As a result of this litigation, poorly financed schools and districts did receive extra funding, but educational improvement didn't actually occur. This might be because overall expenditures on education stagnated or declined, but either way, that's not a particularly optimistic outcome. As a result, state-level litigation has focused on shifting the adequacy in educational inputs to the adequacy in educational outputs. From funding changes to changes in the curriculum and governance changes, courts have generally taken a hands-on approach and ordered states to take action to raise the level of education above the constitutionally mandated requirement. Courts have done this because of the inadequacies in the legislative process in reforming education. Now I'm going to hand it off to Sophie, who will talk about the right to education in India.
Thanks, Kayla. That was an interesting discussion of the most central cases to the to education in the United States. I'd like to follow your discussion with an exploration to the right of education in India. To provide a little background here, let's look at the structure of the Indian Constitution and how it classifies human rights. In essence, human rights are split into two sections. Part 3 of the Constitution is entitled Fundamental Rights and outlines key civil and political rights, including the right to life, equality, free speech, and freedom of religion, among others. According to Article 21 of the Constitution, no person shall be deprived of his life or personal liberty except according to procedure established by the law. The rights listed in Part 3 are those that are integral to maintaining life and liberty and are therefore legally enforceable by courts of law. In contrast, Part 4 of the Constitution includes the directive principles of state policy. These include social and economic rights, among which number the right to education, livelihood, housing, and healthcare. Relevant to our discussion of education here, there are 3 articles in Part 4 that specifically address this right. Firstly, Article 41 states that the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in times of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. Article 45 provides for free and compulsory education until children complete the age of 14. And finally, Article 46 stipulates that the state shall promote with special care the education and economic interests of the weaker sections of the people, and in particular of the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. However, unlike in Part 3, Article 37 and Part 4 of the Constitution, although acknowledging that these principles in this section are fundamental and should be taken into account when creating legislation, makes explicitly clear that these principles are not enforceable by any court. Despite the clear language in the text making Part 4 of the Constitution non-justiciable, the Supreme Court of India has generally found that the right to education can in fact be enforced under Part 3 of the Constitution, especially because of the language of Article 21, which protects personal liberty and the right to life. As an example of how the court has achieved this, let's turn to the 1993 case of Uni Krishnan, JP and others versus the state of Andhra Pradesh. This case involved a challenge by certain private professional educational facilities to the constitutionality of state laws regulating excessive fees charged by such institutions. An earlier case, Mohini Jain versus the state of Karnataka, found that these fees were in violation of a citizen's right to education under the Constitution. In essence, the court in this case affirmed that excessive fees were illegal, but private institutions were allowed to charge higher fees within reasonable limits. However, the case at hand is of interest to our discussion of rights to education, not because of the final outcome, but because of the analysis of constitutional law presented in the holding. The court invokes Article 21, which ensures that no one will be deprived of their life or personal liberty. Life in this context is construed very broadly. In another case, Olga Tellis versus Bombay Municipal Corporation, the right to life was ruled not to be merely freedom from something like the death penalty. That's but one little facet of it. A right to life also means a right to a livelihood, because no person can live without a means of living, that is the means of livelihood. Deprive a person of his livelihood, and you shall have deprived him of his life. The court then references Bandua Mukti Morcha versus Union of India, in which the court found it necessary to construe the Article 21 protection of the right to life in light of the directive principles found in Part 4. The court stated, this right to live with human dignity enshrined in Article 21 derives its life breath from the directive principles of state policy, and therefore it must include protection of the health and strength of workers and of the tender age of children against abuse, opportunities and facilities of children to develop in a healthy manner, and in conditions of freedom and dignity, and educational facilities. These are the minimum requirements which must exist in order to enable a person to live with human dignity. In light of these precedents, the court finds that the right to education is implicit in and flows from the right to life guaranteed by Article 21. Importantly, without an education being provided to the citizens of India, the objectives set forth in the preamble of the Constitution cannot be achieved, and the Constitution would fail. The court, however, does not find that the right to education is without bounds. The court looks to Article 45, which stipulates that the state shall provide free and compulsory education to those under 15 years of age, and to Article 41, which claims that the state shall, within the limits of their economic capacity, make effective provision for education. In short, the court derives a rule from these principles. Right to education, understood in the context of Articles 45 and 41, mean A, every child of this country has the right to free education until he completes 14 years of age, and B, after a child completes 14 years of age, his right to education is circumscribed by the limits of economic capacity of the state and its development. Despite the largely rosy outlook one might have for achieving universal primary education in India, in light of this holding, full realization of this goal is yet to be achieved. Firstly, in 1999, Human Rights Watch found that fees still constitute a practical barrier to primary education. Between exam fees, uniforms, books, transportation costs, and other supply costs, school can be prohibitively expensive for poor families, and often female students will disproportionately suffer as parents are more likely to assign less value to female education. Secondly, not all states in India have passed compulsory primary education laws making it mandatory. Myron Weiner, a commentator, asserts that this might be due to India's reliance on child labor to expand its import industry and promote the small-scale sector. Therefore, without complementary changes to child labor laws and marriage laws, ensuring universal primary education will not be possible. All right, next let's take a quick flight from India to Belgium to discuss the European Convention. While in India we discussed the general right to a primary education, in Belgium we're going to explore what sort of schooling is guaranteed to children and how much choice there is in methods of schooling. Again, let's explore a little bit of context here. Article 2 of Protocol number 1 of the European Convention on Human Rights protects the right to education. It states that no person shall be denied the right to an education in the exercise of any functions which it assumes in relation to the education and teaching. The state shall respect the right of parents to ensure such education and teaching is in conformity with their own religious and philosophical convictions. But in practice, how far does this right actually extend, and how much say do citizens have in the design of state schooling programs that align with their preferences? Hmm? All right. Let's turn to the European Court of Human Rights for answers. In the Belgian linguistics case, the applicants, French-speaking parents who lived in Belgium, asserted that the law of the Dutch-speaking regions of Belgium where they lived did not include adequate provisions for French language education, and their children were forced to take lessons conducted in Dutch against their wishes. Here, the European Court of Human Rights held that the right to education implied the right to be educated in a national language and did not include the provision that the parents' linguistic preferences had to be respected. The court begins by remarking, there is therefore no doubt that Article 2 does enshrine a right. It remains, however, to determine the content of this right and the scope of the obligation that it places upon states. The court then examines the aim of Article 2, stating that it is merely a guarantee to persons subject to the jurisdiction of the contracting parties the right, in principle, to avail themselves of the means of instruction existing in a given time. The article is broad as the convention lays down no specific obligations concerning the extent of these means and the manner of their organization or subsidization. In examining whether an educational system is in line with Article 2, the court says the education system must achieve a couple of things. Among these considerations, the educational system must permit a student official recognition of the studies he's completed, which is to say some sort of degree or diploma. And secondly, the educational system must strike a just balance between the protection of the general interests of the community and the respect due to fundamental human rights while attaching a particular importance to the latter. Having these considerations in mind, the court concluded that states did not have to respect parents' linguistic preferences, only their religious or philosophical convictions. However, a couple of questions remain after Belgian linguistics. Firstly, does a state ever have an obligation to provide schooling in a particular language? It seems like there are circumstances in which they must. In another case before the ECHR, Cyprus v. Turkey, Greek Cypriot children were prevented from engaging in secondary school classes conducted in Greek after receiving their primary education in the language because the Turkish occupying forces abolished Greek Cypriot secondary schools. In this case, the same court ruled that the Turkish Republic of Northern Cyprus did violate Article 2, and schooling in Greek Cypriot must be made available. This holding makes clear that under certain circumstances, a state may have a responsibility to provide schooling in a certain language. Any denial of this will be, according to the court, a denial of the substance of the right at issue. Secondly, does the holding of the Belgian linguistics case square with Article 29, 1c of the Convention on the Rights of the Child? This convention holds that state parties agree that the education of the child must be directed to the development of respect for the child's parents, his or her own cultural identity, language, and values, for the national values of the country in which the child is living, and the country from which he or she may originate, and for civilizations different from his or her own. We'll talk about this last question in a moment during the discussion portion of the CLE, but with that, we'll conclude the lecture portion. This has been Sophie Dush and Kayla Maryberry with the University of Chicago's Global Human Rights Clinic. Thank you so much for joining us.